Hello everyone, I am Chiquilin Galdo and today I'm going to report about the different business structures which are sole proprietorship, partnership, and the revised corporation code. Your choice of whether your business should be a proprietorship, a partnership, or a corporation can be important for many reasons. Each has an advantage and a disadvantage depending on the type of activity that your business is engaged in. The business structure you choose influences everything from day-to-day operations to taxes to how much of your personal assets are at risk. That's why it is important for us to understand these different business structures so that we can choose a business structure that gives us the right balance of legal protections and its benefits. Okay, so let's begin to understand sole proprietorship. Now we're going to understand the concept, how is it formed, the requirements for registration of the business, and the advantages and disadvantages of forming a business under a sole proprietorship. Sole proprietorship is the simplest form of business organization in the Philippines. It is encumbered by the strict regulatory laws and rules imposed upon corporations and partnerships. The single proprietor has unlimited liability in the sense that creditors of his businesses may proceed not only against the assets and property of his business, but after his own personal assets and property as well. Creditors with whom he had incurred personal debts may also run after the assets and property of his single proprietorship business. Simply put, the law does not make any distinction between his personal affairs and his business transactions. Before the eyes of the law, they are one and the same, his business being a mere extension of his person. So how does one register as a sole proprietor? Businesses must register with the Department of Trade and Industry and secure a certificate of registration. So there are three ways of registering with the DTI. It can be purely over the counter, which can be done at any DTI field office, or it can be an online filing where you can file an application through their website. And third, it can be a hybrid or a combination of over-the-counter and online application. After registering with the DTI and acquiring the certificate of registration, you should register with the barangay office where the business is going to be located and acquire a barangay certificate of business registration. And you should also go to the mayor's office and acquire a mayor's permit. And lastly, you have to register with the Bureau of Internal Revenue to acquire a certificate of registration. The following information are also required in getting your certificate of registration. You need to provide your proposed business name, at least 3 in order of priority. You need to also provide your business address, indicate your business activities, and the territorial scope of your business, the owner's full name, owner's address, owner's date of birth, owner's citizenship, and the tax identification number of the owner. So your DTI registration is valid for 5 years. Applications for renewal should be filed within the first 6 months from the expiry of the registration. If the renewal is made during the last 3 months thereof, a surcharge of 50% of the registration fees shall be imposed. You will also be required any 2 of the following valid IDs in this list. either a passport, valid driver's license, Professional Regulatory Commission ID, National Bureau of Investigation clearance, police clearance, postal ID, voter's ID, GSIS ID, SSS ID, TIN ID if you have it, OA ID, Siemens book, and other government IDs. Now let's go to the advantages and disadvantages of registering your business in a sole proprietorship. So, advantages of this type of business structure is that you're basically the boss, and it is very easy to start with because of the minimum requirements that you need to submit. You also keep all the profits to yourself because, of course, you are the one who put up the capital. So the income from the business is taxed as also your personal income, and you can discontinue your business at will. So if you decide to go to another country and stay there permanently, so you can choose to end your business, and it will be a lot easier. It's also very easy to manage with no necessary formalities or regulations about having a board of directors, committee, or meeting minutes if you register under this. Now let's go over to the disadvantages of this kind of business structure. So firstly, you assume unlimited liability for all the debts, the losses, and the liabilities of this business. Secondly, the amount of investment capital you can raise is also limited. And third, you need to be a generalist, so you have to retain high caliber employees, and that would be very difficult if you're gonna just do it alone. And also, lastly, the life of the business is dependent on the owners. So, in case that there are also lawsuits filed against the business, they are also deemed as lawsuits filed against the owner, and the creditors of the owner or the business itself can reach both the business and the owner's personal assets. And if such lawsuits are successful, the owner is obligated to pay the damages with his or her own money. So that's the downside of having this kind of business structure. Now that we've understood this sole proprietorship business structure, let's go over to partnership. Now let's dive in deeper to partnership law. So, a partnership is a contract of two or more persons who bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So, partnerships in the Philippines are governed by and covered under Articles 1767 to 1867 of the Civil Code of the Philippines. And it must be also registered with the Security and Exchange Commission. The registration is done by filing the Articles of Partnership, which will set forth all the terms and conditions mutually agreed by the partners. So, this type of business structure proceeds from the concept that persons may be allowed to pool their resources and funds to engage in the pursuit of a common business objective without necessarily organizing themselves into a corporation, upon which the law imposes a much higher form of regulation, limitation, and standards. Now let's go over to the types of partners and partnerships there are, because there's so many types of partner that you can become if you and your friends decide to put up a business, for to gain profit or whatever your purpose may be. So let's start with a general partner. The general partner is the one who is liable for partnership debts to the extent of his or her separate property after all the assets of the partnership have been exhausted, while the limited partner, on the other hand, is only liable for partnership debts to the extent of his or her capital contribution. Now, as to the capital contribution, there is the capitalist partner who contributes money or property to the common fund. There's also the industrial partner who contributes his services or industry to the partnership. And we also have a, a mix of both, which is a capitalist and an industrialist partner who contributes both money and services to the partnership. While in terms of classification, you can be a managing partner who manages the business or the affairs of the partnership, a liquidating partner who takes charge of the winding up of the affairs of the partnership after it is dissolved. You can also choose to be a nominal partner who is not actually a partner but who may become liable as such to third parties, such as a partner by estoppel. Or you can be an ostensible partner who is active and known to the public as a partner, such as by allowing his name to be included in the firm name. Or you can choose to be a secret partner who has no voice in the management of the business, although you share in the profits and losses of the business. Or it can also be this type of partner, which is a dormant partner who does not participate in the management of the business and is also not known to the public as a partner. There are many types of partnerships, but these are the common ones that we have in the Philippines. So we have a general partnership wherein all partners are liable to the extent of their separate property after partnership assets have been exhausted. We also have a limited partnership wherein there is at least one general partner and one limited partner in the business. And lastly, we have the general professional partnerships, which are formed by persons for the sole purpose of exercising their common profession, and no part of the income of which is derived from engaging in any trade or business. For example, like lawyers who start a law firm or accountants who start their own accounting and auditing firm. Those are examples of GPPs. Now let's go over to the requirements you have to submit to the Security and Exchange Commission if you want to register your partnership. So you first have to have the name verification slip with the reservation of the partnership name. Second, you need the articles of partnership. Third, you need the registration data sheet. Fourth, the affidavit of a partner undertaking to change partnership name. And fifth is a certificate of bank deposit. If the partnership has foreign partners, the following additional requirements must be filed. One is the SEC form number F105. Two, the bank certificate on the capital contribution of the partners. And third is for foreign partners who want to register their investments with the Bangko Sentral ng Pilipinas, they need to provide their proof of remittances. You also need to provide the following information. So you have to put the name of the partnership, the principal office, address, your telephone number, the names, the citizenship, and the address of the partners, the capital contribution of the partners, and the purpose of the partnership. Now let's go over to the requirements you have to submit to the Security and Exchange Commission if you want to register your partnership. So you first have to have the name verification slip with the reservation of the partnership name. Second, you need the articles of partnership. Third, you need the registration data sheet. Fourth, the affidavit of a partner undertaking to change partnership name. And fifth is a certificate of bank deposit. If the partnership has foreign partners, the following additional requirements must be filed. One is the SEC form number F105. Two, the bank certificate on the capital contribution of the partners. And third is for foreign partners who want to register their investments with the Bangko Sentral ng Pilipinas, they need to provide their proof of remittances. You also need to provide the following information. So you have to put the name of the partnership, the principal office, address, your telephone number, the names, the citizenship, and the address of the partners, the capital contribution of the partners, and the purpose of the partnership. Now let's go over to the partner's liability and dissolution. So as a general rule, the liability of partners in a partnership organization is unlimited in the sense that the partnership creditors may run after them for any and all of their assets and property in payment of the partnership debts. Should one of the partners defray all liabilities of the partnership, he or she is entitled to be reimbursed by the other partners for their respective shares. But in the case of limited partnerships, the law allows the limitation of the liability of certain partners to the extent of the amount contributed to the partnership. Now, the dissolution of a partnership is allowed by the Philippine laws for any reason, provided that such dissolution does not amount to a breach of contract or is prejudicial to third parties. The death of a partner or the unauthorized transfer of ownership of his share in the partnership, in case there is a limitation to this, results in the dissolution. In other words, any change in the composition of the partnership will result in the dissolution of the partnership. So the remaining partners may form a new partnership with less or more partners if they desire to. So now that we've understood the different types of partnerships and the kinds of partners that you can be, let's now evaluate the advantages and disadvantages of this business structure. So, a first advantage would be if you are in a partnership, so there would be more than one owner, the ability to raise funds may also be increased. And prospective employees may also be attracted to the business if they are given the chance or the incentive to become a partner someday in the firm or in the business. And they can also be cost effective as each partner specializes in certain aspects of their business. Aside from having a wider pool of knowledge, skills, and contacts, the partnerships also provide moral support and will allow for more creative brainstorming. Now let's go over to the disadvantages here. So on the other hand, the profits must be shared with others. So that's also one of the goals of starting a partnership, which is to divide the profits among themselves. And since the decisions are shared, some disagreements can occur in the operations and handling of the partnership. And it may also have a limited life, as what we said a while ago. In the dissolution of a partnership, it may end upon the withdrawal or death of a partner. And before making really big decisions, you have to consult your partner and negotiate more, as you cannot make these decisions by yourself. So, in here, you really have to decide on how you value each other's time and skills, and what happens if one partner can put in less time due to personal circumstances, and what should be done with it. So, in summary of what we had just learned, a partner has certain rights in the partnership, and thus he has a share in the profits of the partnership and has the right to a specific partnership property. As a partner, he has a right to participate in the management, inspect partnership books, and can, in fact, demand for a formal accounting. However, rights have corresponding obligations. Hence, a partner is obligated to give his contribution and share in the losses. However, as between the partners, the industrial partner is not liable for losses, while a limited partner is liable only to the extent of his or her contribution. So now that we've learned all of the things that are involved in starting a partnership, you may decide wherever your business fits perfectly. Now let's talk about the corporation as a business structure and the revised corporation code of the Philippines, or RA 11232. So, what is considered a corporation, and what are its attributes? So, a corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. So, the law governing the private corporations in the Corporation Code of the Philippines, or Batas Pambansa Bilang 68, which took effect on May 1, 1980. But on February 20, 2019, the government passed the revised Corporation Code of the Philippines, which is known as the RCC, RA 11232, which aims to make it easier to register and maintain a business in the country. The incorporation documents should be filed with the Securities and Exchange Commission still. So, under the RCC, it's still the same. The paid up capital of Philippine corporations must not be less than 5,000 pesos, and thus it is still required that at least 25% of the subscribed capital stock should be fully paid up, but the amount of which should not be less than 5,000 pesos. Now let's take a look at the classification of corporations. There are actually many classifications of corporations. We have stock corporations, non-stock corporations, domestic and foreign corporations. We also have private and public corporations, religious corporations, lay corporations, eleemosynary corporation, which is organized for public charity, and lay corporation has a purpose other than ecclesiastical or religious corporation. We also have a civil corporation, a de jure corporation, which has been created in strict compliance with all the legal requirements, and whose right to exist as a corporation cannot be successfully attacked in a direct proceeding for that purpose by the state. And next we have a de facto corporation, which is defectively created, but there is an exercise of corporate rights and franchise resulting from an attempt in good faith to incorporate on the part of its members. We also have a parent or holding corporation, a subsidiary corporation, an open corporation, and a closed corporation. The detailed definitions of these corporations will be included in my written report that you can download in the email that will be provided after. Now let's go over to the salient features of the RCC. So the revised corporation code also integrates technology into the corporation code, allowing for remote participation, online registration, and monitoring and electronic communications for business registration and corporate compliance. The RCC also updates the old corporation code and makes it at par with international standards. The creation of the one-person corporation and corporate perpetuity make it easier for foreign and Filipino entrepreneurs to enter the local market. Now let's go over to the 6 salient features of the RCC. First, we have the one-person corporation. So in the Philippines, 99% of businesses are small or micro enterprises. But with the new code, they can now register, or MSMEs, or micro, small, or medium enterprises, can now register their businesses under this new legal structure. In the old corporation code, at least 5 people were required to incorporate. Now, the new code allows a single person to form a corporation as long as they are either natural persons, a trust, or an estate. The primary advantage of registering as a one-person corporation are they have separate legal identity from the business owner, unlike what we discussed a while ago if you register your business under the sole proprietorship. Second, the owner is also liable to the extent of the shares invested in the business, unlike in the sole proprietorship, wherein you can be liable up to your personal property. And last, personal assets are considered separate and protected from the liability of the business. So the following types of businesses may not be pursued through a one-person corporation. These are the banks and the quasi-banks, the insurance, pre-need, and trust companies, the publicly held and listed companies, the non-chartered GOCCs, and mining and oil companies, and some public utilities. So you might be wondering why these businesses aren't allowed to be pursued through an OPC. So the answer to this is that these businesses are vested with public interest. So because these classes of corporations are required to have at least 20% of the board constituted of independent directors, which is a requirement an OPC by its very nature cannot comply with. So that's why sadly these cannot be a one-person corporation. This is pretty great, right? Because these businesses will have all the benefits that a corporation can get, but not all types of businesses can be pursued through a one-person corporation. So let's take a look at what may be pursued. So first we have the practice of profession. So pursuant to the provisions of Section 10, a natural person can pursue the practice of his profession through a one-person corporation only when authorized by the special law that governs the practice of that particular profession. So an example of such a special law would be the Architecture Act of 2004 that allows the registration with the Securities and Exchange Commission of architectural professional corporations. Second, we have service companies. So a natural person can pursue the rendering of his or her services other than in the practice of profession through an OPC which thereby retains him or her as an employee or a consultant. If you have a holding company, it can also be pursued through an OPC as long as you are organized by a natural person single stockholder and you merely hold title to properties, real or personal, except when it comes to holding title to private lands where the single stockholder must be a Filipino citizen, and when holding shares in a corporation engaging in a nationalized business or industry where if the single stockholder is a foreigner, the amount of equity held in the corporation should not exceed 40% of the voting capital stock, nor the 40% of the entire outstanding capital stock. However, last March 10, 2020, the House of Representatives actually approved a bill allowing 100% foreign ownership in power, transport, and communications sector. So the House Bill 78 seeks to amend the Public Service Act and delineates between the terms public service and public utility, which the 1987 Constitution prohibits foreign ownership of. The nation's charter sets a limit of 40% for foreign ownership on similar services and utilities. But the lawmakers behind the measure argued that the bill would usher in more foreign investors and would boost competition. So that is just something that kind of contradicts to what our constitution originally mandated. But lastly, also all other lawful business enterprises may be pursued through an OPC by the single stockholder, except as expressly provided in Section 116, which are the following kinds of businesses. The second salient feature of the RCC is perpetuity. So the revised law allows corporations to exist in perpetuity unless their articles of incorporation provides otherwise. Business owners no longer risk their company closing down prematurely, allowing them to create long-term value and investments. Because before in the old corporation code, businesses or corporations in general are only allowed up to 50 years of operation unless they extend the life of their business. So, the perpetual corporate term applies to both aspiring and existing corporations as well. No further paperwork is required for availment, and expired corporations can petition the Securities and Exchange Commission to revive their existence. The majority of the former board members of trusts or trustees must be in agreement with the revival. Corporations whose name is now being used by another company must file under a new name, and any outstanding fines and liabilities must be paid before filing. The third salient feature of the RCC is the online registration system. So what's great about this is that in order to improve access and efficiency, the Securities and Exchange Commission is transitioning to an online registration system. The Department of Information and Communications Technology has been charged with creating an online portal through which all business registrations and related licenses and authorizations can be completed. So it's now very convenient for individuals to file their registrations under the RCC because of these improvements. And the fourth salient feature of the RCC is the remote participation and voting in absentia. So the revised code takes advantage of modern telecommunications. Notices of board meetings may be sent electronically, and the board members and trustees can use video conferencing teleconferencing, and other technologies to participate in board meetings remotely. Shareholders will also be allowed to vote in absentia. So this is very convenient for those board members who are not in the country or is not in the location of the meeting, because they can now use Zoom or Google Meet in order for them to have their meetings done. The next salient feature would be the increased security deposit for foreign branch offices. So the minimum security deposit required for foreign corporations increased from 100,000 pesos to 500,000 pesos. The deposit ensures international corporations can meet any obligations or debts incurred in the Philippines. But there are corporations that are exempt from the security deposit. These corporations are the following: foreign banking corporations, foreign insurance corporations, foreign non-stock corporations, foreign corporations with established representative offices in the Philippines, and the regional headquarters, area headquarters, and regional operating headquarters of multinational companies. And the last salient feature of the RCC is that the corporations vested with public interest. So the Securities and Exchange Commission defines such corporations as those whose securities are registered with the SEC and those listed with an exchange. Corporations with assets of at least 50 million and having 200 or more holders of shares, and financial institutions such as banks, quasi-banks, non-stock savings and loan associations, pawn shops, money service businesses, pre-need, trust and insurance companies, and financial intermediaries. Corporations vested with public interest must elect a compliance officer. Additional annual reports must be also filed with the SEC, and such as director compensation and performance reports. Stockholders have an absolute right to vote in board elections either remotely or in absentia, and at least 20% of the board must be independent. So now that we were able to understand the concepts, the attributes of the RCC and its salient features, now let's go to the advantages and its disadvantages. So the first advantage of forming a corporation is that owners have limited liability. So it is considered by law as separate and distinct legal entity. So the shareholders are only indebted to the extent of their interest in the corporation. This means that their creditors can only run after the assets of the corporation and not on their personal assets. Second is it can exist with continuity. So the power of succession gives a corporation continuous existence. Unlike a sole proprietorship where the death of the owner, proprietor, ceases its existence, the death of a shareholder will not terminate the corporation. The next advantage would be that shares of ownership are transferable. The stock or interest of a publicly traded corporation can be traded easily through a stockbroker. Shares of corporations are freely transferable except when shareholders have buy-sell agreements restricting when and to whom shares may be sold or transferred. And it can also attract more investors. So corporations attract investors because of its stock structure, perpetual existence, ownership transferability, and limited liability. And attracting more investors allows a corporation to raise more capital or equity to manage and expand their operations. So now let's move on to the disadvantages of corporations. So under this business structure, incorporation is really costly. And in order to file with the Securities and Exchange Commission, it may involve a lot of formal and legal papers such as bylaws, articles of incorporation, affidavit, and board resolutions. This is sometimes done by getting the service of a corporate attorney or firms which are specialized in incorporating a business. It may also require higher amount of initial or paid-up capital for any other types of corporation, like financing and lending corporations. The amount of subscribed capital is taxed with documentary stamp tax, which may result to additional expenses to be incurred by the incorporators. And we also need to consider that corporations are highly regulated. Ordinary corporations are regulated by the SEC, whereas special corporations may be required with secondary licenses and are further regulated by other government agencies such as the Bangko Sentral ng Pilipinas for financing and lending companies, Commission on Higher Education for companies operating secondary schools, and the Insurance Commission for insurance companies. Another disadvantage would be a limited liability may discourage creditors. So the limited liability feature of the corporation can be an advantage for stockholders. However, it can also be a disadvantage when a corporation doesn't have a good financial condition and performance. And it is not easy to dissolve. So corporations are difficult to dissolve as it is also difficult to form. Everything is regulated from formation to operation and to dissolution. An application for dissolution must be filed with the SEC with complete requirements, including tax clearance with the BIR, and the liquidation process is also regulated to ensure that the rights of any of the creditor having a claim against it is not prejudiced. So now that we are done with the three business structures, it's up to the businessman which kind of business structure is the right fit for what they are planning to engage on. But choosing the type and form of your business needs a lot of prudent considerations. It may involve assessing your financial resources, taking inherent risks, and considering your preparedness. I hope that you were able to understand the concepts of my little report well, and here are the references that I have used in this report. Thank you so much for listening and stay safe, everyone.